Welcome everyone to this new episode of the Privacy Rules Privacy Espresso series, a series where we delve into the latest on privacy, data protection, and technologies from all over the world. Today with me, I have Yugo Nagashima from the law firm Frost Brown Todd, that is exclusive member of the Privacy Rules Alliance for the United States, to share with you some news related to the country, and in particular regarding a new proposal for what is called the American Privacy Rights Act. That seems something very interesting to hear about. So Yugo, thanks a lot for being here with us today, and feel free to give us an overview of what we are talking about.
Yeah, thank you for inviting me to the Espresso. American Privacy Rights Act of 2024, it's still built. We'll just call it APRA going forward. And I just want to say, this isn't the first try that the US federal government tried to pass a comprehensive federal privacy law. This is its second try. And I want to share with you some of the items that's been reintroduced, or in some of the items that's been changed, and what I expect to see going forward. And of course, this is, my guess, so don't hold me to it. And if that's okay, we'll be happy to discuss it.
Sure, that's a bet, let's say. But in your opinion, it's always useful, as everyone or most of our listeners knows very well, GDPR and EU regulation. Maybe a good way to address it is going through the differences, the key differences that you see between and the similarities between those two laws.
Sure. So let's do similarities first, and I want to get the big ticket items out. The definition. The definition of personal data and in the APRA, we call it covered data, is very similar, right? So it's the processing, it's the collection, retaining, or transferring of personal information, which means it's the information that identifies or is reasonably linkable to an individual. Very similar definitions, right? Also, the similarities is the rights that individuals have, or the consumer data rights. And those are, of course, everyone who does GDPR knows, right to access, correction, deletion, portability, very similar, right? There's also a section on data minimization, and the GDPR, it's more of a principle, and it's hidden behind the statutory language, but there's a concept of data minimization. And APRA, data minimization, is actually like a section, and there's a statute to it. So that's very similar as well. And also the concept of having a data protection officer in the GDPR, in the US, having a data privacy or security officer, or having both, is now required if the law passes, right?
Okay, and Hugo, one question that I wanted to ask you, just to clarify with our listeners. Does this act means that all the laws in the US will be unified thanks to it, or there are still some differences that remain?
So the answer is yes and no, right? So one of the things we do know is, and I do want to get into the differences, right? So
yeah,
yes, to the extent that there is state laws, comprehensive privacy laws in the states, the federal law currently, as it's going through the Congress, has a section on preemption. And what preemption means is that the federal law, if it passes, would prevail over state laws that may have also comprehensive privacy laws. That said, remember, the U.S. is it's sectorial, meaning different sectors have different privacy laws, and people who have studied U.S. privacy laws should know that there's HIPAA, which is the Healthcare Portability Act, right? There's also GOBA, which is the Financial Act. There's also FERPA, which is a Student Data Privacy Act. There's also COPA, which is the Children's Privacy Act. Those are all carved out, so they don't get preempted. But for state privacy laws, there is a preemption clause. That said, and it also adds an additional confusion, because for certain consumer laws, right, consumer protection laws, APRA doesn't preempt, so it's still going to be a little bit confusing. It's not as unified as the GDPR you have in Europe.
But maybe this is also because it's still a work in progress, so some things
Yes.
probably will be more defined in a second stage. And sorry to interrupt, I think this was very useful to know, but of course, for what concerns the differences from what we are in Europe, which one would you be focusing on the most?
Okay, so the focus would be the covered entities, the entities where the law is going to apply. As we know under the GDPR, you could be Google, huge company, right? You could be Facebook, huge company, or you could be a parish or an individual, right? Who's basically having names, lists of people's names and addresses and phone numbers, who's calling for purposes of, having a meeting for the church, right? There was a case out of Germany, I think, a long time ago. Under APRA, it passed in the current form. Again, it's still not there. There is a threshold. If you're a small business, you're kind of exempt, right? And the threshold is if you're an entity that, the revenue is more than $40 million and processing the covered data, right, of about 200,000 individuals, right? If you're less than $40 million revenue and, you're not processing that much personal data or covered data, and then you're exempt, right? Then you don't fall into APRA.
Okay, that's very clear, and it sounds like something, and it's understandable because, as you rightly mentioned, this is still something that is being structured or under work, let's say,
Right.
But seems to be a pretty complex framework to deal with. And in your opinion, which are in particular for companies that fall, because you were also explaining to us about the threshold, which are the key issues that companies should be aware of in relation to this proposal, let's say?
Okay, so there's two big ones that I see, and the two issues is one that's already addressed a lot in state privacy laws, which is, again, the differences. I want to go back to the differences between the GDPR and the US system, which is GDPR is a opt-in consent system, right? US has opt-in for sensitive data, but for the most part, it's a opt-out system. And what we're concerned in the US is targeted advertising, right? Where you're collecting the information, personal information, and you profile the individual so that you can send certain targeted advertising. So there's an opt-out mechanism for that, and that's still the same, right? That's a difference. In the GDPR, you have to get consent beforehand. In the US, if it's not sensitive data, for the most part, you have to opt out. You as an individual has to opt out, saying, hey, don't collect my personal data, don't sell my personal data. Of course, the US system requires you to notice, but you're still collecting, right? While the GDPR is you notice and get consent. So that difference still exists. The other big aspect that I would look out for, especially with APRA, and I'll get into more detail, is there's a private right of action, right? The private right of action is the right for individuals whose rights that may be violated due to breach of the APRA law, if it passes as is, would have the right to basically bring a lawsuit against the company who's breached the APRA rules, right? APRA compliance. This is very different from the previous iteration of the federal privacy law draft, and it's different from a lot, I would say pretty much all of the US state privacy laws. The CCPA has a little section, right of private action, but it's limited to data breaches. The APRA private right of action is broader. It includes more than data breaches, and it includes also the violations of the obligations in APRA as it stands right now, right? And of course, this is all assuming that if the statutory language we have today survives,
of course,
there is some concerns, I say, for companies, because if they're not complying with the current version of APRA as if it passes, there's a risk that there might be a lawsuit brought from an individual.
which is a big risk, I would say, and something you don't want to deal with probably. And in this regard, I was reading your interesting article on these, and I think another thing you were raising is the time. I mean, in case these proposal pass, then companies wouldn't have that much time to comply. And considering the complexity of what we are discussing about, this may be, an additional problem. So
Right.
on the practical side, what would which should be the approach of companies given the situation that we have right now? What should they be doing in your view?
Right. So I want to get to the time part because I think we should make it very clear for listeners. As the law currently states, and again, it can be changed, but as it currently stands, if this law passes with the current language, after the law passes, both House and the Senate of the Congress, it would be effective in 180 days. Right. That's about what, 6 months, right?
Yeah.
A little less, a little more. I think it's a little less because each month has more than 30 days.
Yes.
But it's pretty quick.
It's a very short time.
And as we just talked about, there is a lot of things to consider. And as it currently stands, there's a lot of risk. So what I would suggest is starting early and complying with at least portions of the APRA that, again, APRA covers a lot of privacy obligations that the state laws are covering, right? If you haven't started, start complying with the state laws and start looking into the obligations, because I do think in general, the basic coverage of, let's say, giving a notice, the rights that you have to provide, the compliance aspect of, if you're a large data holder, right, then you have to do an impact assessment. I'm pretty sure if you're a large data holder, you already do it, but you haven't been doing it, it should be done. And also considering data minimization, which is a good practice, and I think which is a value add for a company to tell their customers that they're data minimizing, because not only does it build trust, but it also may reduce costs, right? If you collect less data. Putting those measures within a company in place will be very helpful, because when time comes to comply, you'll be halfway there, right? Then there'll be minor issues that you'll have to adjust, but those can be dealt with talking to a attorney or a privacy expert in the field.
Yeah, that's great tips. Thanks a lot. And I also believe, to complement with you, that if you are already complying with something, often the authorities, when run after you, if they do, normally they apply lower sanction or no sanction at all. So they are more keen to discuss with you instead of just, punishing you. So
Right.
This can be a point. And the other one is that we are witnessing, more and more law proposal. Even just if you look at the US, privacy is really becoming a thing. There are many new laws that are popping up country by country. So it's just a matter of when something like this will, become real. But it's for sure a type of law that will be arriving soon. So probably it's already, a good way to look forward, to start preparing for it if we are like zero compliance, but in general. So in order to do that well, as we could hear, this is very complex. So feel free to contact experts like Yugo, that is giving us this very good overview today. We are running out of our time. So Yugo, thanks a lot for being with us today. Thanks to our listeners, and looking forward to meet you all with our next Privacy Espresso. Bye.